Today, I would like to talk about asset protection techniques for real estate investors and business owners. I want to premise the discussion by saying that asset protection is only appropriate with respect to future claims, not known or reasonably expected at the time of planning. It cannot be used for the purpose of obstructing collection efforts of creditors, but rather to make you less attractive targets of frivolous claims, and to help you separate your business from your personal liability. When you own a business or real estate, especially properties other than your primary residence, you are faced with two types of liability: internal liability and external liability. Internal liability is a liability arising within the asset itself. For example, there is a water damage in the building that you own that resulted in loss of property, or someone slipped and fell on your driveway, and so on and so forth. Speaking of internal liability, what we're typically trying to do is to contain that liability within the asset or business where it originated. In other words, if there is a claim arising out of one property, we don't want it to affect other properties that you may own. One of the ways how you can contain the internal liability is by setting up a separate limited liability company or an LLC for each property or business that you own. Needless to say, it's not enough just to create a company. The assets must be properly retitled, the business formalities must be observed, and the company itself must be sufficiently funded and insured. Only then the LLC would give you the liability protection. Now let's look at the external liability. External liability is the liability created outside of the affected asset. For example, it might be your personal liability that now threatens everything that you own. And even if you have all your assets owned by separate LLCs, since you are the one who owns those LLCs, your personal liability may subject your holdings or income distributions generated by those holdings to claims of your personal creditors and other creditors. One of the ways how you can protect your assets from external liability and make yourself a less attractive target is by placing your holdings in an asset protection trust. In other words, the asset is owned by an LLC, but the LLC, in turn, is owned by a trust as opposed to you personally. That would essentially create a double firewall around your investments. This is by far not all that asset protection planning can do. There are other techniques how you can further reduce the equity available in your assets through the use of third-party lenders and mortgages. Or there are also techniques that would allow you to create revenue sources outside of your trust. Also, there are distinct kinds of asset protection trusts and jurisdictions which offer a variety of options and asset protection features. But you need to remember that no matter how good Nevada or Delaware may sound, if your property is located in New York or New Jersey, there is a good chance that protective structures created in other, more asset protection-friendly states may not work. This type of planning is almost always state-specific, both in terms of the state of your residence and the state where your assets are physically located. If you have any questions or want to talk about any of these things and how it applies to your specific situation, please feel free to give us a call at our office number 201-380-2000 or visit us online at www.thelawofaging.com.
Novitsky Law Group is a full-service elder law and estate planning law firm. With 4 offices located in Paramus, Morristown, Jersey City, and Red Bank, we serve communities throughout New Jersey and New York. Call us at 201-380-2000 or visit us online at www.thelawofaging.com. Make sure that you subscribe to our newsletter to stay up to date on important developments in estate planning and elder law.